just write it at the top of your
exhibit.
thing.
I mean, I sat here and listened to this for 20 minutes, and you're just making stuff up at this point.
Is that an objection?
Yes, that's the objection, they're making stuff up.
I think we're at motion for some judgment 5.
Yep.
5 or
Hoping. That's one of mine, so I'm hoping.
Let me make sure I did here. Is that motion? Which one are we on?
I believe 5, you're right. Is it 5?
Oh, okay. Oh, the adulterated product.
2.
Yeah, I think motion on limiting number 5, that real water and UNFW sold and adulterated product. Is that next up?
I believe so, Your Honor.
Okay. So let me clear that one. Let's change.
So, Your Honor, I'm going to do some more factual educating in this motion. To give you a little more context on why we believe the motion should be granted, and will summarily kind of address the oppositions. But before I do that, John, do you have any particular questions you want me to address, any issues you want me to focus on?
Not yet, but I probably will.
All right. So you learned yesterday, Your Honor, that the FDA investigated Real Water and then ultimately filed a consent decree providing that Real Water provided an adulterated product. And the investigation started March 16, 2021, and completed April 7, 2021. During that time, they tested the concentrate, as Mr. Kemp has said several times yesterday as well as today, and found that each one of those tests, hydrogen, levels that would cause injury, or at least levels that, pursuant to CFRs, would make it an adulterated product. As a result, the FDA, CDC, and Southern Nevada Health District required the recall and the pulling of all Real Water products. So that would be 5-gallon jugs as well as the retail bottles. Now, I make that point because I think it's important to understand there is no differentiation between the jugs and the bottles. And all of the discussions regarding the Henderson location versus the DI location versus the Mesa, Arizona location is just red herring, Howard. Every location used the same, very same recipe for the concentrate. Now, the consent decree was signed by Brent Jones and Blaine Jones. And you saw testimony yesterday from Blaine Jones. Blaine is the son of Brent Jones. Brent Jones and his wife were the owners of Real Water. Blaine Jones also was the PMK for Real Water and an officer of Real Water. Honorable Judge Dorsey, Federal Court Judge Dorsey, signed the decree on May 31st, 2021. On page 3, Your Honor, of our brief, and Shane, can you bring that up for the court? And highlight the paragraph starting at lines 12 through line 20. Here we go. So these are particular provisions of the decree, Your Honor, where you can see it's highlighted here. It was determined by these public authorities or agencies that the Real Water product is adulterated within the meaning of 21 U.S.C. 342, as well as 21 U.S.C. section 334K and 21 U.S.C. section 342A4. This motion is designed to determine, have the court determine, by Rule 56, that the product sold by Real Water and distributed by UNFW was adulterated. What we've heard thus far, and Mr. Kemp has gone through this ad nauseum almost, that every expert that we deposed and asked whether or not hydrazine should be included in water, have all testified that it should not. UNFW's expert, Dr. Atkinson, said real water should not contain hydrazine. Dr. Goldsmith, in his deposition as well as in his report, says water should not include hydrazine. Milwaukee's expert, Henry Heidel, testified that hydrazine should not be in bottled water. Our real waters expert, Dr. Richardson, testified that hydrazine should not be in drinking water. There have been 10 tests of this product, 3 by public agencies and 7 of retail bottles by UNFW, paid for by UNFW's council or by UNFW. Every test has determined hydrazine has been in the retail bottles, 7 bottles, and 3 within the concentrate. There's been no test done of the water where hydrazine was not found. And so the closest call is within the 7 bottles tested. 2 may have been I guess, below or not to a level where it would register for purposes of determining hydrazine as a potential adulterated product in those 2 bottles, but it was found in all 7 bottles. And that test result was, those tests were completed on March 28, 2023, so roughly 3 months ago now. 4 months ago. And as Mr. Kemp said, Dr. Goldsmith testified during his deposition that those test results from UNFI was the smoking gun. Now, Rule 56, and this is something that I believe UNFW attorney raised in his opposition. I think Mr. Neale said that Rule 56 does not allow the court to make a determination unless that Rule 56 motion is identifying a claim or a defense. Now, that's the first line under the title, under Rule 56A. But if you read just a little further into the second line, it says, or the part of each claim or defense. Your Honor, we're asking this court to determine that an adulterated product is a part of our claim not only, but as an adulterated product is a defective product. No one expects to receive rocket fuel in their water if they buy bottled water. In fact, I think most of us have a bottle of water on our desk today, and I would be upset, not only sick, if this had rocket fuel in it. The point is we don't expect it, it shouldn't be there, and every expert has opined that, unfortunately, hydrazine is a toxin that causes liver failure or liver injury. So, we cited the Church of Scientology versus Richardson, Your Honor, 437 Fed 2nd 214 is a 1971 case. And it indicates in this, as a part of the holding, that the FDA's determinations, unless arbitrary and capricious, are determinations that can be used in court. And so, it's our belief, Your Honor, based upon our motion, that the court can find by summary judgment that the product sold, the water sold by Real Water and distributed by UNFW is an adulterated product, the fact that it would be established by summary judgment and is appropriate under Rule 56. One of the points raised by UNFW's opposition was whether or not the test done in 2023 or the test done in 2021 by the FDA or the CDC or SNHD would be conclusive in terms of real water sold in 2018, 19, and 20. I think that's the thrust of UNFW's opposition. Your Honor, what is not in their opposition, and a reason why I believe this is again a red herring, is that there's no discovery that's been provided that the recipe for the concentrate changed between 17, 18, 19, 21, 22, 23. all of the real water bottles and jugs were all made from the same concentrate. There's no reason to believe that the recipe was changed, because the depositions have borne out that the recipe was not changed. The depositions have borne out that the recipe was made in a secure location, within a secured room, and used for both the jugs as well as the retail bottles. So there is no evidence to suggest that anything was done differently, which would have created a new recipe or a new concentrate, which would have not included hydrazine. So, Your Honor, I struggle to figure out if there's been some evidence that simply has been withheld from the defendants, showing that there's some other toxin or some other recipe. But based upon where we are in discovery, since discovery has been closed, there is no objective testing identifying a single other toxin other than hydrazine that would have caused the plaintiff's liver injuries. The defendants also raised this issue of whether or not there were sufficient quantities or concentrations of hydrazine in the bottles versus the jugs as a defense. Your Honor, I don't believe, again, that that's a relevant consideration for this motion. There is no evidence to suggest that the hydrazine sold was any different than the hydrazine tested. I'm sorry, the real water sold was any different than the real water tested that's been found with hydrazine. Yesterday, Your Honor, Mr. Kemp provided the article prepared by the Morbidity and Mortality Weekly Report, a November 19, 2021 chart. And it actually showed the spikes of hepatitis. One of the spikes was after August of 2020, and there were spikes also at 18 and 19. And in fact, can you bring up Exhibit A to UNFW's opposition? Shane? So that's the consent decree. That's Exhibit I. I would like to see Exhibit A, if you could.
Bear with me.
Oh, no worries.
I don't have it, Teddy.
You know?
We can pull it for you. John, would you pull up Exhibit A, please, for Mr. Parker?
I appreciate it.
I think it's the same wavy graph I was using.
Same one?
Same wavy graph.
WR.
Yeah, that right there. That's what he wanted.
It's going to be the next
There you
page,
go.
John.
It's the second page.
Yeah, Teddy, we have it. If they could give us back control. There
Okay,
you
that's all right. I mean, that's fine, Shane. We're good. I wanted the court to see the spikes on this chart, which is a part of this page 2 of the article that Mr. Kemp used, Your Honor, yesterday. And if you look at the chart here, it shows the November 2020 spike. But you can also see a spike in 2018, 2017, and medium-type spike in 2019. And so when the defendant suggests that there's no indication that the real water had an effect or caused injuries prior to 2020, that's simply not true. And this document confirms that there was a spike in reported liver injuries prior to 2020. Your Honor, the definition of adulterated is the presence of toxins that is capable of causing personal injury. We have experts, in this case, our own experts, but certainly Dr. Goldsmith was retained by Real Water, that simply identify hydrazine as the only known toxin based upon the testing in real water capable of causing liver injury. That's what the evidence is in this case. No other toxin, no other cause that we're aware of. And we have experts that we've retained indicating who have reviewed the medical records, who determined that hydrazine was the cause of the plaintiff's injuries, each one. There's no other evidence out there of any other toxin that has been detected through any of the objective testing, and none of the defendant's experts have offered any other opinions. So based on that, Your Honor, we simply ask that the court grant a summary judgment indicating that the real water product was an adulterated product as determined by the CDC and as a consent order that was signed not only by...
Should I really rely upon the consent order?
Your Honor, I think it's evidence. Do you need it as a part of your determination here? I think it supports that determination. But also, I think the objective testing truly is a nail in the coffin, or smoking gun if you want to use Dr. Goldsmith's description.
And I'll rephrase, would it be proper for me to rely upon?
Oh, I believe it's proper based on the Church of Scientology, California versus Richardson case.
Your Honor, Jim Neale on behalf of UNFI. Let me start with the court's question. It would be improper, Your Honor, to rely on the consent decree. Mr. Stevens, can you pull up Exhibit I, please? As you know, having read that, Your Honor, that's a consent decree that was signed by non-parties, Mr. Jones. It was not signed by parties that are here, including Hanna, Milwaukee, and UNFW. It defined facilities. If you could go to page 2, please, John, paragraph 8, and highlight that for the court. It only concerned facilities at Henderson and Mesa from which neither Mr. Haley nor Mr. Belsky consumed real water that could have possibly caused their injuries that occurred long before either of those two facilities were open. But most importantly, Your Honor, it's a compromise. It's barred by 48-105, and it's a no-low plea. It's a no contest. The people who signed this made very clear that these were FDA allegations to which they did not consent. They did that twice. They did it in paragraph 26. I think it's on page 14, John, where the FDA wrote, we're entering this decree without contest and with the defendants not admitting the violations here. That same language is reiterated in the preamble on page 1, Mr. Stevens. Without contest in that first paragraph and without admitting the violations described here. And this is a traffic ticket. And it's a no-low plea to a traffic ticket, and there's no way that's admissible in subsequent civil proceeding, even against the party who signed it, never mind against parties who didn't. So first and foremost, the consent decree is of no moment, and the court's correct to be concerned about the plaintiff's encouragement that it rely on that. Next, let me correct 3 misstatements that Mr. Parker made. Number 1, he said there were no tests of water, real water without hydrazine. There are dozens and dozens of tests of real water that don't show the presence of hydrazine. He said there is hydrazine present at a level in the CFR that defines adulteration. That is incorrect. There is no level in the CFR or in NRS or in an admin code or anywhere that defines a specific level of hydrazine that renders water adulterated. The plaintiff's experts agree on that, the defense experts agree on that. There is no standard. There is no prescribed test for it. It's not on the EPA's 50-state analytic. It's not on the FDA's CFR 129.80 testing. It's nowhere. The third thing that Mr. Parker said that's incorrect is that the definition of adulteration is the presence of a toxin capable of causing injury. I'll get to that in a moment. But that's absolutely not the definition of adulteration. Under either 21 U.S.C. 342, the federal definition, or the state standard, which is, I think, at 585.300. Here's the argument, Your Honor. Adulteration is not a claim or defense to the plaintiffs, and it's not a part of a claim or defense to the plaintiffs. The plaintiffs in a product liability case have to prove defect, not adulteration. Adulteration is a regulatory concept. Defect is a product liability concept. A product can be adulterated, but not defective. We cited the 789 cases of latex gloves case for that proposition, where it's just made, for example, in the absence of an inspection, or in a facility that didn't allow the FDA in, or some other technical regulatory non-compliance, like the absence of paperwork. That product is adulterated, but it's not defective. Conversely, a product can be defective, but not adulterated. That's the Butts case, the salmonella and Morocco. And so the two concepts are entirely different, and one doesn't substitute for the other. If we go to the pattern jury instructions briefly, Mr. Stevens, and we look at the strict liability jury instruction, which I know the court's familiar with. I think it's 701 on page 105, John. If you can blow that up a little bit, maybe I'm the only one having difficulty seeing it. But strict liability, the next instruction for manufacturing defect, the next instruction for design defect, none of them refer to or incorporate the concept of adulteration. They all require defect. And that's what the plaintiff has to prove here, a defect. And more than that, Your Honor, the plaintiff has to prove defect in the product they each consume. That's their burden. They can do that directly, or they can do that circumstantially. But they can't do that by saying that some of the other product might be adulterated. If we go, Mr. Stevens, can you pull up the federal link I just sent you? 21 U.S.C. 342, please. And I think this gets to the crux of the issue, Your Honor. This is the statute under which the FDA alleged that the product was adulterated. And if we go to A1, please. If it bears a poisonous or deleterious substance, which may render it injurious to health. But, and here's the critical part, Your Honor. In the case that the substance is not an added substance, such food shall not be considered adulterated under this clause if the quantity of such substance in such food does not ordinarily render it injurious to health. The definition of adulteration, in other words, incorporates the outcome. And Mr. Parker talked about the bottles of water we all have. None of these is 100% pure. They all have some metal in them, or some pathogen, or some microbe. There's no such thing as sterile water, except perhaps in the operating room. The presence of a harmless, non-pathogenic substance, or the presence of a metal at a level below which the FDA allows, means it's unadulterated water. And that's the case here, Your Honor. That's why even if we assume, and you have to assume, that every bottle that Real Water ever manufactured had hydrazine in it, you have to explain the fact that 10 million bottles were consumed every year around the country without a single case, retail bottles, without a single probable case of liver failure. And that's impossible to explain if you assume, as the plaintiffs ask you to as a matter of law, that every single bottle is adulterated. So that's why you can't do that. I'll reiterate. 21 probable cases anywhere in the country, and they were all home and office delivery subscribers. Despite the fact, Your Honor, that that part of the business represents 2% of Real Water's volume. So let me say that again. 2% of the volume accounted for 100% of the injuries, whereas the retail bottles, which comprise 98% of the business, resulted in 0 probable cases. There is enormous circumstantial evidence that the retail bottles were not adulterated. And that's exactly what all of our experts have said. Can we pull up, please, Exhibit N, Mr. Stevens, at page 44, 45. This is Dr. Atchison, to whom Mr. Parker referred earlier, and he was asked by Mr. Kemp, beginning at line 6 on page 44. He was asked, not only is hydrazine undesirable, but the FDA had determined if there was any hydrazine, even a small amount in a retail bottle, it would deem that an adulterated product, right? And Dr. Atchison, the former chief medical officer of the FDA's Center for Food Safety and Applied Nutrition, said, no, that's not how it works at all. There's all kinds of chemical residues and impurities that are in the food we eat and the beverages we drink, and they're not adulterated unless they normally cause injury. Dr. Dara, our hepatologist, said the same thing. Dr. Postenbach, our toxicologist, said the same thing. Last one, I think I made the point, but even the plaintiff's expert, Dr. Hudson, could you go to Exhibit Q, please, Mr. Stevens, at page 100. Even the plaintiff's causation expert says there is a level at which hydrazine isn't harmful. And I don't know what that level is. John, can you blow that up a little bit? I'm sorry. Or may I? Scroll down, please, John. It's further down. So here's Dr. Hudson asking himself the rhetorical question. How much do you need to drink to have a liver injury? We don't know. I don't think anybody knows. And we'll get to this when we talk about Dr. Hudson's opinion. It might be 1 bottle, it might be 5 bottles, it might be 10 bottles, but nobody knows. And the simple, inescapable fact, Your Honor, is that the mere presence of hydrazine at 1 part per billion, as was found in some of the retail bottles, is not sufficient to cause injury. We know that from the very strong circumstantial evidence. We know that from the plaintiff's own causation testimony. And we certainly can infer that from the defense experts. So I'll leave it at that, Your Honor, but I'll remind the court that this is the plaintiff's Rule 56 motion. The non-movements get every reasonable inference of fact and law. And there is very substantial evidence that this product was not adulterated, not capable of causing injury, at least in the retail capacity. And for that reason, the court has to deny the motion for summary judgment. Thank you.
Okay.
Didn't we have joiners?
Yes, Your Honor. Matthew Kaufmann on behalf of Real Water refiled a response. I'm just going to be very brief. Mr. Neale did a very good job. One, as Mr. Neale pointed out, I don't, and I agree with Mr. Neale in this respect, that it is not proper to rely on the consent decree in this case, just based on the simple language of the consent decree. as we don't even believe the consent decree is admissible as evidence, and we'll discuss that later. The other point I just wanted to raise real quickly was that, once again, we believe the reliance on Dr. Goldsmith's testimony is misplaced, and is not supportive of plaintiff's motion. And that's all I have for now. Thank you, Your Honor.
Is there anyone else who joined in?
That's it?
Is that Mr. Robbins? Mr. Rasmussen, is that?
We did not join, Your Honor.
Okay, all right, I just want to make sure, I thought I saw more than one, but maybe.
Jim, can you put Exhibit I back up to your opposition?
Sure. So I can't, but somebody smarter than that could.
Somebody on this side of the room can do it. If you could blow that out, please. Paragraph 26, if you go to paragraph 26. There we go. It says here, defendants consent to the entry of the decree or any testimony has been taken without contest, without admitting the violation described here. That's what it says. It doesn't say that they dispute. They simply do not admit that the violations occurred. But the decree itself, which includes the paragraphs 4 and 5, indicating the product was adulterated, is present in this document. The document was signed by the court and accepted by the parties. And when you said certain parties were not, certain parties, in this case, was not a party that consent decree agreed. Real Water, however, was. Its owner signed it, one of its lead officers signed it, and the determinations by the CDC had been signed as a part of this decree by Judge Dorsey. Now, when you made the comment that this decree only references the Henderson location, the results of this decree was that Real Water, in all of its locations, Mesa, Henderson, they no longer could sell the Real Water retail bottles or the 5-gallon jugs. They were all pulled. That was the result of this decree. And because it was pulled because the product was adulterated. That's the reason behind the recall. And when you indicate, which I hope you use this argument in front of the jury, that this was nothing more than a traffic ticket. Traffic tickets typically don't result in deaths or liver transplants or hundreds of thousands of dollars in medical care. Typically, a traffic ticket, you get stopped, you get a ticket. If you're a lawyer, you may be able to handle the ticket yourself, you may hire someone to do it, or you may pay the fine. But it doesn't result in a recall of every car you were driving. It doesn't result in a recall of that car or you being able to drive any further unless you're a terrible driver and you've gotten in trouble many times. The point is, in this case, this consent decree resulted in every real water product on the market being recalled. That's more than a traffic ticket. That's a very serious issue, and it was serious because it caused serious health injuries. Testing for hydrazine, when testing for hydrazine was done, hydrazine was found. This comment, this somewhat of a kind of play on words made by Mr. Neale, Your Honor, was not every test resulted in a determination of finding hydrazine. Well, not every test was designed to determine if hydrazine is present. There's a certain type of test required to actually be able to identify hydrazine. So every test designed to find and identify hydrazine resulted in a finding of hydrazine. That's the gamesmanship. I don't want to say gamesmanship. I think Mr. Neale is simply presenting his argument. So I don't say that critically towards Mr. Neale. But that's the difference between a test looking for hydrazine and a test not designed to find hydrazine. Every test designed to find hydrazine found it, John. And every expert has opined that rocket fuel or hydrazine is a toxin that can cause liver injury. And then Mr. Neale points to the fact that there's no standard for hydrazine testing for bottled water. There's no standard for it because no one expects to find rocket fuel in bottled water. There's no standard for thumbtacks and bagels. I don't expect to bite into a bagel and get poked by a thumbtack. Because you don't expect, no one expects to find rocket fuel in bottled water. The fact that hydrazine, when a product is tested for hydrazine, was found in every test, tells us that the product is defective.
Now I have a question for you in that regard, because, and I've been listening to the argument, I had some thoughts, and is there a difference between a product being adulterated versus a defective product unreasonably dangerous under the restatement of torts 42A?
Great question. Mr. Neale tried to address it in part.
'Cause
He's
that's
trying to
a
draw
big
this
difference.
very
I mean,
wide.
I understand the restatement of torts 42A, and the focus is on the product, unreasonably dangerous, and so on and so on. And so, at the end of the day, that's what I think it comes down to, because we're asking for a determination of adulterated. Potentially, products can be adulterated and not a defective product, unreasonably dangerous, potentially. I mean, we can dig a little deeper. But really and truly, what is that? What is the thrust of this? And I do understand you did say, look, Judge, and I thought about your argument as it pertains to Rule 56, A, and I did review the language, and it talked about a claim of defense, and also said, it does say, or part of a claim of defense.
Exactly.
So my point is this, how is this part of a claim of defense, and just as important too, what impact, if any, does it have, and or relevance as to 402A?
Yes, John. A bottle of water containing rocket fuel is defective. Adulterated can simply be exchanged for defective in terms of the caption of this motion. Mr. Kemp just brought something up, which admittedly is not in the moving papers.
But I mean, there's a difference between a defective product and reasonably dangerous under the restatement, right? We can all agree to that, versus adulterated.
I'm getting ready to hit that point. But I agree, Your Honor, there is a difference. And in this case, which I believe is consistent with the Nevada Supreme Court, the C-rate case, which identifies the consumer expectation test. A product is defective if, in this case, a bottle of water includes rocket fuel, which no consumer would expect to buy a bottle of water that included or contained rocket fuel. So for purposes of this motion, we can say unequivocally, based upon the testing, and there's no testing to the contrary, that the product sold by Real Water, be it 5-gallon jugs or retail bottles, based upon the testing, contain hydrazine, which certainly would, given the C-Ray Supreme Court case, Your Honor, would not be expected by any consumer. And so as a result, it was a defective product. And Your Honor, I want to also focus in on Dr. Goldsmith's report once again. He addresses some of the comments made by Mr. Neale. Now, I will say that Mr. Neale did not retain Mr. Goldsmith. He was retained by Real Water. Mr. Neale did not retain Goldsmith, so UNFW didn't retain Goldsmith. But if you could, Shane, go to page 8. Who's controlling this right now? Shane,
Okay.
or someone decide? You?
Me, Terry.
Okay, good. I didn't know if you had control of it. So page 8 of this report. It says here, there does appear to be evidence that Real Water was contaminated by hydrazine known to be a liver toxin. That's Real Water's expert testimony. These are the conclusions within his report, Your Honor. And if you could go to page 7, Shane. All right. And if you could go up a little bit. And when we were talking about the difference between, Your Honor, the 5-gallon jugs and the retail bottles, the defense likes to separate themselves, first, especially UNFW, from the bottles by suggesting to you that it's only the 5-gallon jugs. Dr. Goldsmith says here, last sentence of this full paragraph here, because Real Water managers mixed the concentrate that contained hydrazine, the company may therefore bear the responsibility for plaintiffs, plural, liver injuries. Your Honor, there is no difference between the 5-gallon jug and the retail bottles. There's no difference in that they all contain hydrazine, which Dr. Goldsmith believes is a toxin that will, of course, injure your liver and cause the plaintiffs, plural, injuries. To be adulterated versus defective, I believe, Your Honor, if it's hydrazine, it's both. It's adulterated in terms of the FDA determinations or CDC's determinations, and is defective when you consider the C-rate case. And we did not cite to the C-rate case, but Your Honor is very familiar with the C-rate case.
I mean, I am, but I was just kind of going through the motion, and I'm familiar with it. I understand the consumer expectation has been life. But I think before I could even consider pulling that trigger, you gotta have briefing.
I agree, Your Honor. And that's why I did it up front.
It has to be.
It wasn't addressed.
And here's my point too. I do see a distinction between adulteration potentially and an effective product that may be dangerous under restatement of George 42 Act. There is a distinction there. I mean,
So, Your Honor, I believe we would be inclined, because it's true, we did not cite to or discuss the C-rate test in our motion or in the reply. And in fairness to the defense, I know the defense did not address C-rate in their opposition. We can simply provide supplemental briefing to the court on this subject.
Actually, it's not C-Ray, it's Trejo versus Ford Motor Company. That was Justice Stiglitz's opinion where she adopted the consumer expectations test. And the defense, the motor vehicle companies were arguing that we should adopt instead a different standard. But that's the recent case that talks about the consumer expectations test, which is, would a consumer expect this type of defect in the product? And given the fact that all their experts have already testified that it shouldn't be in the product, you should not have hydrogen, rocket fuel, and real water, they fail the consumer expectations test automatically. But I do think we cited to Trejo, which is the appropriate case. Or I should say the appropriate, it is the more recent case. It was Justice Stiglitz's case from 3 years ago.
So C-Ray and then this project.
all right. But is that a different call of the question? And my point is, I think I have to have it thoroughly vetted. Because if I'm gonna rely, because the defense will get a chance to distinguish any of that, is that correct?
That's correct, Your Honor.
No, that's incorrect, Your Honor. I'm looking at our brief right now, and they argued that it didn't meet the standard of adulteration. And so we went and we took one term that they defined adulteration. If you take a look at our reply on page 6, they admitted that adulteration can refer to any kind of pathogen or toxin capable of causing personal injury. This is what we're talking about in this case. This is what Mr. Neale showed you from the jury instruction, the word defect, okay? The word defect, that's what we talked about here. And again, like I've already said, the right case is but a more recent case, more accurately, is the Trejo case, Trejo. The Trejo specifically.
What page is that on in
It's in the reply brief on page 6, Your Honor, where in the opposition, they went into this long thing about, okay, to be adulterated under the FDA standards, you have to do this, that, or the other thing. And in part of their opposition, they admitted, and that's where I cited page 9, lines 24 through 25, they said adulterated can refer to the presence of a pathogen or toxin that's capable of causing personal injury. So we said, fine, let's accept their definition of that, which is the defect that he's shown us. And let's analyze that. And we did, okay? We did. And we showed the evidence, they're experts again, distinguished this argument they made on there's no testing on the retail bottles supposedly in 2018 and 2019. And so I think it's already in the brief, Your Honor.
Your Honor,
No, let me, I was gonna go. Your Honor,
so we're on the horse.
no, listen, I thought you were gonna say thank you on this one. Your Honor, my point was, I see Mr. Kemp's point in terms of the factually is addressed. But in all fairness, I didn't see where we actually addressed the consumer expectation test. And that's all, I think that's what Mr. Neale's gonna come back and say ultimately. I do believe the court is, in the years I've been before this court, has preferred to have all of the authorities represented or presented in the motions and then, of course, explained in oral argument, so that whatever decision the court makes ultimately would have been well briefed and well argued.
It should have been by the deadline. There's no consumer expectation theory. And of course, Your Honor, consumer expectations are limited to defects. The problem is in this case that the plaintiffs are trying to pound the square adulteration peg into the round defect hole. The two things don't match. The court has to deny the motion on that basis and on the basis that even under adulteration, there's competing evidence and the non-movements get the benefit of the doubt in every inference. So this is a frolicking detour that the court need not indulge in, and we should go back to the motions as filed, and the court should stick with its apparent inclination, which I believe is absolutely correct, that adulteration and defect are two entirely different concepts.
I was with him for a second, John. I retract everything I said a few moments ago. He was completely incorrect.
And Tony, that last comment he made regarding the distinction between adulteration and defect under the restatement of torts 428, because I want to make sure I'm not missing anything.
Your Honor, I do agree with Mr. Kemp that from a factual standpoint, it is explained, that issue is addressed in the reply brief. I was simply trying to afford a defense an opportunity if they wanted to brief the issue on the restatement second, as well as the consumer expectation test, that we would do so, especially since the defense has asked for and the plaintiffs agreed to supplemental briefing on the difference between general and specific causation. But if for some reason Mr. Neale is not willing to accept the invitation to supplemental briefing on the item, then I think our reply addresses factually why this product was adulterated and defective and why the motion should be granted. So we'll defer to the court's wisdom on this. If additional briefing would be beneficial, certainly willing to do so. It appears that defense would not like that opportunity. But we will, if the court would like to have some additional briefing on it.
Anything else?
No, Your Honor.
Yeah, what I'm going to do as far as this motion is concerned, I'm going to deny the motion. I do see there's a distinction between adulteration and an effective product that needs to be dangerous. And the problem is that this specific issue wasn't addressed when it was raised in the reply. As far as this appears to be an issue we might have to address head on. Are there any motions regarding the defective product angle?
Your Honor, there is a motion that addresses this so-called 10 million bottles sold, no defect, and it's a fake argument. Defendants make these kind of arguments up all the time. And that's addressed in the motion to preclude the so-called legal history defense, which is specifically precluded in this jurisdiction by Bailey versus Thomas. So that motion does address that particular part of the argument. Which other?
To answer the court's question, no, there's not a motion about declaring a defect.
Other than one that just argued.
All right, well, is it time for lunch? You think? I think so. How about 1:15, come back?
1:15, Your Honor. Your Honor. All right. So you tell me, you can do whatever you need to do in this courtroom. We'll walk after we meet. Everybody. Department 61, now return session. Please be seated.
Thank you. Let's go ahead and set forth our appearances on the record. We'll start with the plaintiff.
Looking for plaintiff? Eric Pepperman, plaintiff?
City Clerk, plaintiff.
Your Honor, Jim Neale for UNFI, together with Ms. Anderson, David Spurlock, and Nick Kaufmann.
Thank you.
Good afternoon, Your Honor. Joel Odou and Matthew Kaufmann of Real Water and the Lifestyle Robbins and Milwaukee.
Scott Rasmussen, and reading live on behalf of Hanna Instruments.
Good afternoon, Your Honor. Jim Kavanaugh, Real Water, Tennessee.
Right, did they cover all appearances?
Did, Your Honor. I talked to Mr. Pepperman during the lunch break. Consistent with yesterday, there were several different full transcripts of depositions with their accompanying exhibits that you had requested. I have a couple that I brought with regard to our client depositions that we took that you may or may not need, but in an abundance of caution, we have gone ahead and made copies for you, and it's okay, I'd like to approach and give those to you.
All right, any objection?
No, Your Honor, I looked at them, there are copies of the depositions if you need them.
So are the accommodations?
Yes,
Thank you very much.
much appreciated, Your Honor.
Thank you, sir. Okay, so where do we go next?
We're at motion for summary judgment number 6.
Okay. Okay, Mr. Kemp, do you have this one, sir?
Yes, Your Honor. Your Honor, the full title of this motion is summary judgment number 6. Taking negative ore readings of alkaline water is a particular purpose of the meeting. And so, backing up a little bit, we are not asking the court to decide all the elements of the breach of implied warranty claim. For example, we are not asking the court to decide that the meter was not fit for this particular purpose. We are not asking the court to decide the causation issue. All we are asking the court to do is say that one of the particular purposes of the warp meter was to take negative warp readings of Canadian water. That is it. And when we get down to it, we'll rely upon their general manager's testimony that he knew it was being used for this purpose, and we'll rely on their product literature, where they expressly promoted it for this purpose. But before we get that, I'd like to try to put the warp meter into the context of the case, because this is the first time we've talked about the meter.
Yes.
This is an MW500 warp meter. Okay, this is what it comes packaged in. We'll open it up, take it out of the package. You've seen, I think, flashes of it, Your Honor. This is the user manual, which we contend didn't give adequate warnings. This is the actual meter itself, which has the LED readout on it, which I'll show you on the screen in a minute. And this part is this part is what is referred to as the probe. Okay, you dip, the probe has a platinum tip on it.
And is a probe the part of the instrument that has to be cured in some form or fashion?
That's correct, Your Honor. The probe, hopefully this one doesn't have water on it, most of them don't, some of them do. Get it off. Oh yeah, there's the probe. The probe is this little needle sticking out that has platinum on it. Okay, so what you do is you stick the meter into whatever substance you're trying to get a positive or negative reading from, and then the reading pops up here. You connect these together. There's a string that connects them together. And you look at the reading, and that's it. It's either positive 180, negative 170, whatever it is. Okay, the problem we contend with the meter is that when you take it out of the box, you can take positive readings right away. We don't have to do anything. We could just start taking positive readings right away. To take negative readings, you have to condition the probe. You have to do one of two things. Either you have to use the conditioning solution, which you can't do anymore because they've taken it off the market, or you have to put it in vinegar for 5 days. Okay? And they don't advise you that in the user manual. They don't advise you that you have to do any conditioning, much less that you have to put it in vinegar for 5 days. So that's our contention as to why this probe is defective. It's defective because without an adequate warning or instruction, it doesn't tell you the danger. The danger is inconsistent readings. It doesn't tell you how to do it. Okay, so now let's get back to the motion today. The motion today is just that one of the particular purposes of this device was to take negative readings when making alkaline water. Now, let's start with how they make alkaline water at this particular plant. Shane, can I have my first slides, please? In this case, there's three steps they take to make water. Okay, the first step is they make the concentrate. We've heard a lot about the concentrate. And you see that little thing that looks like a slingshot? Okay, that's not a slingshot. Those are the titanium tubes that you've probably heard a little bit about. So the story goes from the inventor. The inventor was this person named John Marlowe. Marlowe testified, I took his deposition twice, that he met a Russian in the late 80s, early 90s, I can't remember. And the Russian told him about this procedure to make alkaline water that used these titanium tubes. So he actually purchased 12 of these tubes from the Russian that he later resold to Real Water. Okay, so what they do first of all is they make the concentrate that contains the hydrogen in it. So to do that, they take regular tap water from a local municipality and they run it through a purification machine, which filters out all the impurities. That's really not important. Basically, they make purified water. Okay. Then they put it through these titanium tubes. Now, why are they putting it through the titanium tubes? They're trying to separate it between alkaline and acidic water. So to do that, they put you can't see it in this picture, but there's a place on the tube where you can put an electrical attachment. So they put a positive charge on one and electric on the other, and there's a little diaphragm in the tubes. And what that does is it separates the water into two categories, one being alkaline and one being acidic. Then they take what they get and they run it through one more time, okay? But in order to hold an electrical charge, remember I said this was purified water. Purified water will not hold an electrical charge because there's nothing to ground to. So before they run it through these two tubes, they add some chemicals, which really aren't germane to this motion, but it's a potassium chemical and another one. And they do that just so there's some sort of charge to separate the water. So this is the first step of the process, making the concentrate. And this is the step of the process that the expert's going to testify. They inadvertently made hydrazine. And Dr. Najee is going to be the expert on that. There's really not a lot of controversy about this. But anyway, this is the first step. So they make the concentrate, and then they put it in these big 300-gallon concentrate vats. Do you have a picture of that? Step 2, 3. Okay, so this is not a concentrate vat. These are the actual water vats. So what they do is they purify the water, then they put them in these, looks like one's 500, one's 900. So they take the concentrate, they've made the concentrate, they take the 5 gallons of concentrate and add it to 100 gallons of real water, and that's the ratio, 20-1, okay? That is how they make real water. Now we get to the third step where the ORT meter is involved. Next one, please. So they take the ORT meter, and after they've added the concentrate to the 100 gallons of water, they take the ORT reading. Because what they want is, their objective is negative 225 to negative 50. The whole theory of alkaline water is that it has a negative ratio, and so when you drink it, it'll be some kind of oxidant to the body. Like for example, Dasani, we're going to see something about Dasani here in a second. Dasani usually has a plus 125. Regular drinking water is usually plus 125. This, they want to make negative so they can sell to the public as some sort of antioxidant. That's the whole reason they're taking negative reading. So they use the ORT meter, they put it in the mixture, and they take a reading. And like I said, their target is negative 225. If it's under negative 225, they add more concentrate. So as I said this morning, Mr. Akins, the October instance, calls up Blaine Jones. He's already thrown one 5-gallon container in there. Says, what should I do? It's negative. He adds more concentrate. All right? So by adding more concentrate, he is doubling the amount of hydrazine in the final mix. So that is why the meter is so important, because the meter is the sole determinant as to whether to go with the original 5 gallons of concentrate or add more concentrate. All right, next one, Shane. Again, this is just the titanium tube. I think you can see it a little better. You can see where the electricity goes onto it. Okay, next one, Shane. This is the actual concentrate tank. It's a separate tank. That's a 300-gallon tank. They put the concentrate in. You see the spigot in the bottom. That's how they fill up the 5-gallon things. Next one, Shane. Again, these are mixing tanks. Next one. Okay, that's the ORT meter. That's one that we actually have in our possession that we took from the Henderson factory. But that's the same thing I just showed you, Your Honor. Next one. Okay, this is very important. These are the product instructions that they issued for the conditioning solution. So they made this product for about 35 years. So after the product was out on the market for a little while, they decided they had a problem. Can we go down to the statement about the problem? Okay, and the problem, further down there, Shane. Okay, stop right there. Stop. Up. Okay, stop. Okay. So they're talking about reoxidizing, and they're talking about the oxidation kit. So what they say in this is how you use the oxidation kit. Because when they were doing the probe in vinegar, they found that people were getting inconsistent results. That's not my phrase. That is the phrase that they have in the, can we find that inconsistent statement? I think it's in the, yeah. Down with the chain. Yeah. Okay, this proved to be an inconsistent method to oxidize the probe. So they were letting people use it in vinegar and acidic water. It was causing inconsistent readings, okay? I think you've seen counsel object a couple times when I use the word inconsistent. That's their term. This is their product literature, Your Honor. And take a look at the next two words. This problem They knew it was a problem. They knew that the probe wasn't giving consistent readings under this oxidation technique, and that's why they came out with this conditioning solution, okay? And the conditioning solution kit is called the MA9025, and like I said this morning, it was on the market for a while, but then the European Union made them take it off the market in 2017. So they take off the solution to the problem in 2017, and they just keep selling the meter. They don't tell them they've got to put it in vinegar for 5 days. They don't even tell them there's a problem. They just keep selling the meter, all right? And that is the primary defect in the meter case, in the instructions. Next one, Shane. All right.
Positive reading video?
Yeah. Okay, Your Honor, this is an instructional, there's a motion to pre-admit the YouTube video. What happened is Real Water was, for a while, they were not just making real water, they were making these little blue bottles, and you're gonna see one of them in the video. And the blue bottle was the concentrate, so you could go out and make your own real water. They were just selling the concentrate on the side. So this video is a video that Blaine Jones, again, he's the vice president, the owner's son. So Blaine Jones made an instructional video telling people how to use the meter. Okay, the instruction video is very important for a couple reasons. One, you will see in the instruction video that he has a card that he's prepared for everyone behind him, and it says put the meter in vinegar for 5 minutes. That's what they thought they were supposed to do, because there's no instructions in here. So that's the first important thing. The second important thing is I think it'll show you exactly how the meter is used in this case. Go ahead. Now this is the positive. First, he puts the meter, you see how he's putting the meter in Dasani water? That's just regular water, doesn't have any real water in it, so it's a positive charge.
Let me get audio on this video.
Okay. And this probe's properly conditioned because this probe is the one you use the conditioning solution to condition. So look how long it takes. Now you see the meter reading, he's at 119, 120. He's going up positive reading. So it takes about 12.23 seconds for that reading to stabilize. That's how long it usually takes to use this meter, somewhere between 12 and 20 seconds. So he's using the meter to measure positive in the Dasani water. Now next one, he actually adds the real water concentrate. You see the little blue bottle there? He adds that to the Dasani water, and he's trying to demonstrate that he's taking a negative measurement. Can I see the next one? You see he's squirting the concentrate in there, adding it to the Dasani water. And you see the meter on the left, you see how we're going to the negative? You see we're in the negative now? And I had Shane just time it from when it was at 0 to negative. And the meter actually stops there about negative 180, 185. But this is the way they were using the meter to make the real water, okay? So let's go back to the original manufacturing process. The original manufacturing process, they would dip the probe into the solution that had the concentrate and mix it in, and they're trying to get to 125. If they see it's under 125, they add more concentrate, more hydrogen. Okay, next one, Shane.
See brown deposition?
Yeah. Okay. 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 All right. Now, this is Jason Brown. One of the issues in the case is how long does it take for the meter to work if you don't properly oxidize it? And they say, oh, it doesn't take that long at all. This is the general manager of Milwaukee. He's up there in the top right screen. I'm going to play his deposition. He's their person most knowledgeable. We've got a motion to declare him a managing speaking agent. So we asked him, how long, if you don't condition it, will it take to give you a negative reading? Remember, I just showed you it took 18 to 20 seconds when Blaine Jones was using it? This is his answer. Go ahead, Shane.
Mr. Kemp, we're having some problems with the audio. Let's try it and see what happens.
Okay.
Yeah, I think it's because we're going through the blue jeans.
Okay.
Can we switch to the doc cam,
Use the,
Madam
I'll just
Recorder?
read you the question and answers.
We can
Switch
switch
it
to
to
doc cam. Just switch.
To doc cam?
Yes, ma'am.
Is that doc cam?
Apologize for the wait, Mr. Kemp.
Would you prefer to go through the transcript?
Yeah, why don't we just do the transcript? You know, so we asked him when we took his deposition,
Go back to blue jeans, Madam Recorder.
we said, all right, if you don't oxidize it, if you don't put it in vinegar for 5 days, how long does it take for the meter to do a negative reading? And question, are we talking hours, days, months? What are we talking? Answer, hours to days is what he would say. Okay, so rather than the 15 to 20 seconds I just showed you for a properly oxidized meter, if you don't oxidize it, it takes hours to days to get a reading. They don't say anything about this in the product literature. And with regards to positive ore, works fine right out of the box. You don't have to do anything. It does the measurement right out of the box. That's the testimony right there. The negative ore, it won't do that. It will take longer. And I asked him one more time, how much longer? If you put the ore in Kangen water, and Kangen water is a type of alkaline water that's common in Japan, so you will hear the term alkaline water, Kangen water, it means the same thing, Your Honor, it's just a type of alkaline water. So I say, okay, using the ore meter to measure Kangen water, it won't give you an accurate negative ore reading, is that correct? He says, oh, I didn't say it wouldn't give you an accurate reading. It's not gonna be as fast. Not gonna be as fast, it's gonna be hours or days. But eventually, if you keep the meter in there for hours or days, it's gonna give you the right negative reading. So that's the problem in the case, Your Honor. Is that the end of it, Shane?
No, it continues.
Okay, and again, this is their general manager. Now they're trying to run away from this. They're saying, oh, when he said this, he was sick. Okay, that's why I wanted to play a video to show you he wasn't sick, Your Honor. And then they said, oh, he was ill-informed. He's the general manager. This is what he's done for the last 12 years of his life. He sells these meters. How can he be ill-informed? But anyway, this is what he said. Okay, so now I told you that they warned about inconsistent results in the oxidation kit literature. And the reason they're doing that is they're trying to sell the oxidization. Okay. So they're saying, ladies and gentlemen, here's a problem, and this oxidation kit cures it. Buy our oxidization kit. But they don't say this in the meter literature. And the next issue is, well, what evidence do we have that when real water was using the meter, it wasn't working right? Well, as I told you before, in the Jones video, we have the, right there, Your Honor, see, I said there's a little pop-out box on the left. This is what he thought you were supposed to do. Put it in vinegar for 5 minutes. Not 5 days, 5 minutes. And that's pretty much what everyone at Real Water says their understanding was when they bought a new meter. And they bought 90 of these. They bought 90 different meters from this company. Next one, Shane, the personally consistent. So the next question is, what evidence do you have that the meter wasn't working right when Real Water used it? Well, first of all, this is their own product literature. Again, it says if you don't oxidize it right, in other words, if you don't sit it in vinegar for 5 days, you get inconsistent readings. That's what their literature says. Okay, this is what they tell people in the thing. And then we started taking depositions of the people that were actually using the meter. This is a guy named Diego Mendigana. He was on the retail line. Remember I said this morning the deposition plant had 2 lines, one for 5 gallons and one for retail bottles? This was the head guy on the retail line. So he says right there that they had a calibration problem. Next he says, I think there's another one, Shane, where he talks about the 18 to 20 times. It should be 31, 4 through 11. 31, 4 through 11.
That's what this, oh,
That's
31.
34. Okay. So I say leave the other people aside because he starts to tell me about all the people that had problems with this meter. So I just want his testimony. So in the 3 years he was working on the retail line, how many times did you get inconsistent results? Inconsistent, that's their word, okay? That is their word in the product literature. So I am using their own term to describe the problem. How many times did you get inconsistent results? 18 to 20? Yes, all right? Next bit of testimony. This is from Patty Converse. She is the quality assurance director. She was actually really a receptionist, and then they promoted her to the quality assurance director. That's a whole other story. In any event, this is her testimony about these port meters. Okay, so why don't you think they weren't calibrated every 2 weeks like they were supposed to be? Well, they weren't consistent. We always had to order new ones. They didn't measure consistently. Yeah, so you always had to order new ones. Direct testimony that the meter was not working right. And then we get to the big one, okay? This is Mr. Akins. Mr. Akins was, he was the promoter of the strip club, and COVID came, he couldn't get a job, so he went to work at the Real Water Warehouse, and then when Henderson opened, they decided to put him out to Henderson as the water maker. So this is his testimony about what I call the super bad batch. Again, let's put this in context. This is sometime in the middle of October. Mr. Jones goes on his hunting trip, so he's not around to help Mr. Akins. So Mr. Akins says, oh, well, it came back a little lower, the reading, all right? And so what did I do? I called Blaine. I called Blaine Jones, he's up there in Utah on a hunting trip. And he notifies me to add a little bit more concentrate, so that's what I did. This is the proof of the causation case, Your Honor. They got a low meter reading, so they added more hydrazine, more rocket fuel to the product. Okay, next, let's go down a little bit. So I said, well, what was the lower? And he said, lower than 200? And he goes, 130, negative 130. That's what they got. Okay, they were supposed to get negative 225. That was the objective. That was the whole design of using 5 gallons of concentrate to 100 water. They were supposed to get 225. And so the meter, this showed negative 130. And so what they did is they added another 2.5, 3 gallons of concentrate. And that is the batch that caused the big spike that you've already seen a couple times. All right, so that is the meter case in a nutshell. So all we are asking is that the court find that there's not a disputed fact that one of the intended purposes of the meter were to take negative ORP readings in Kangen or alkaline water. Okay, so what evidence do I have that they knew that the meter was being used that way? Okay, can I have the product literature? Oh, excuse me, before we go to the product literature, I just want to show one thing, Your Honor. We talked about this a little bit this morning. Mr. Parker talked about the spikes, but he didn't really explain the background of this. So here's what happened. The Southern Nevada Health District, when they were investigating the outbreak, they have access to all the hospital data. I didn't know this. They can go in there and they can get into the hospital records of every hospital in town. They don't even have to ask. Okay? They can get in there. And so what they did is they looked at the ICD-10 diagnosis codes. That's acute liver failure. So they went back and they looked at all the cases of acute liver failure here in Clark County in 2016, 2017, 18, 19, and 20 that had an unknown etiology. They couldn't figure out the cause, okay? And so then they made a chart. So you see the baseline, probably somewhere 8 or 9 cases, and then you see all these spikes, okay? Here's the big spike, November 2020. So here we are right about when Mr. Akins makes the bad batch, okay, middle of October. So boom, we have all these bad batches, and you'll hear a lot of testimony that they realized they had a bad batch. So they went out there and they tried to secretly recall the water. They snuck into people's yards and tried to take the bottles back and give them new bottles. You know, they knew they had a problem, okay? But they also had problems, according to the health district data, they had problems like Mr. Parker said, here at the end of 19, here right about August 17, you know, and these are the time periods that we have problems in some of the cases. Mr. Haley and Belsky are right here. You see the spikes in those time periods. So this is the data that allows us to see that this meter was causing problems over a period of time. And this is what you would expect, Your Honor. You would expect that if they're adding concentrate now and again because the meter's not reading right, you would expect to see just what you see here. Now, addressing another point, Mr. Neale said, oh, Judge, there's been, can I have that back, please? Can I have that back? He says, Judge, there's been 10 million retail bottles sold, and we haven't found one single case all across the country. Well, what he forgot to tell you is they didn't do this analysis all across the country. Mr. Neale's just making that statement up out of thin air. And when we get to the Beatty versus, was it Beatty versus Thomas? When you get the Beatty case, you will see that the Supreme Court has expressly held that defense attorneys can't make up their own product history and give it to the jury. You know, you can't defend a Ford Pinto case by saying, oh, God, this is the only one that we know of that's ever blown up. You know, because they haven't done a rigorous analysis. If he had data like this for the last 4 years across the country, and he could show that there were absolutely no unknown cases, maybe he could support his wild claim, but he can't. But anyway, this is the evidence that we have a series of inconsistent results, and especially the peak right here. And further proof to disprove Mr. Neale's claim, okay, this is when we argued about yesterday, when did the Henderson plant open? Okay, it opened sometime, let's say halfway. Okay, let's just say halfway through June of 2020. Look at all these other cases during this time period. So we had problems the entire time period. And why did we have problems during this entire time period? Well, we had problems because it's the same manufacturing technique, same people. They just moved the equipment from one plant to another. Okay, same hydrazine. And we know this to be true because Mr. Neale forgets to tell you, oh, it's all a Henderson problem. Some of those bottles he tested were 2020 bottles. They were made before the move to Henderson, and they still found hydrazine in those bottles. So, don't shake your head, you know it's true. All right, next point,
Mr. Kemp.
moving to the argument. The legal argument here, first argument they make is, oh, it's not properly pled. Your Honor, we pled an unreasonably dangerous claim under Restatement 402. That's the genesis of unreasonably dangerous. Unreasonably dangerous is the flip side of the breach of implied warranty claim. In fact, if you go back and look at case law in the 40s and 50s, you will see that McPherson versus Buick, I think it was, they actually started product liability law by kind of using implied warranty as a springboard. So for them to say, oh, it's not properly pled, first of all, in Nevada, it's a notice pleading state. We don't have to really say anything other than, this is my name, this is your product, and I got hurt. That's all we really got to say. You know, usually we go a lot more overboard than that, all right? So we cited 3 different cases, the Liston case, the Schwartz versus Adams case, and the recent case by Judge Beulah, the drone case. And those were all plaintiffs, all cases where the defendant said, oh, Judge, they called it this, and now they want to call it that tort. And, oh, Judge, they called it this tort, and now they call it that tort. The Schwartz case, the claim tort was conversion, and the Supreme Court held, well, this supports a claim for breach of due process. So even though it's not pled as breach of due process, we're gonna hold it. So the point is, in a notice pleading state, it doesn't matter if you put unreasonably dangerous or you put breach of implied warranty. If the facts support the claim is properly pled. So that's their first argument in summary judgment. second argument in the summary judgment is, Judge, it doesn't matter that we put out the product literature. Can I have a product literature, please, Shane? Well, this is King and Water. It's Exhibit 4. Okay, there we go. This is their product literature, Your Honor. You see the nice little meter there? So what does the product literature say?
Objection, Your Honor. This is not our product literature. It says it's from a different company altogether.
Offer some proof of that. Offer
We'll
some
try
proof
to
of that.
right at the top of your thing. I mean, I sat here and listened to this for 20 minutes, and you're just making stuff up at this point.
Is that an objection?
Yes, that's the objection. You're making stuff up. Look at the top of your exhibit.
This exhibit was offered to your witness. Your witness testified about it, okay? In any event, Your Honor, well, let's go to the witness's testimony.
Why don't you go to the top of your thing and look at the URL?
Let's go to the witness's testimony.
Oh, okay.
Let's go to the witness's testimony. This is Jason Brown again, Your Honor. And the issue is, did they know that people were using the Orb meter to measure, take negative readings? So I'm at 14. I'm at the request for admissions. Admit that you knew in 2020 or before that Orb meters were being used by some purchasers in the process of making water. Do you see that statement? Answer, yes. You knew that too? Yes. He specifically says yes. He's their general manager. And the reason I had to confront him with these requests for admissions is that they wrongfully denied it. They had emails from Kangen water users, and he answered them back saying, oh, I have tons, that's his term. I have tons of Kangen water users that are using my meter to take negative Orb reading. That's in one of his customer exchanges. So even though he knows that there's tons, even though he agrees with the admission, they denied that. They denied that. And that proves it right there, Your Honor, that they knew that this Orb meter was being used by Kangen water purchasers, alkaline water purchasers, to make alkaline water. Now their argument is, okay, Judge, we knew objectively that people were buying our meter for that. And by the way, 1/3 of the purchasers were using the meter for that. Not 1%, 2%, 3%. Over 1/3 of the purchasers were using the meter to make Kangen or alkaline water. So their argument back is, well, Judge, maybe we knew that people in general were using our meter. Remember, this is a mass-produced product. It's not a specialty product. Maybe we knew in general that people were using our meter for this, but we didn't know that Real Water was doing that. Unless we knew that that specific customer of our mass-produced product, you can't stick us on an implied warranty claim. Well, the problem with that is when you look at the statute, 104, the statute says, quote, has reason to know. Has reason to know. And we talk about this in our reply brief. There are 2 cases, we've cited them both, that say that when you make a mass market product, and you know that it's being used for a specific purpose, you don't have to show that they knew about this particular customer also using it for that purpose. Knowledge in general is knowledge of the specific. So they cite Mahisco, which is the carpet case out of Stardust, and they tried to, and what happened is they were ordering a custom carpet for the showroom. In the Mahisco case, wasn't decided on the issue of whether or not it was an intended purpose. It was decided on a reliance issue. But Mahisco, in and of itself, I think proves our point because there was no direct interaction between the ultimate purchaser, the hotel, and the carpet maker, which was a plant. I think it was Neale or Orion, I can't remember which. Because there was a middleman. There was a middleman retailer there. So in the Mahisco case, they held that this knowledge could have been shown just from the plans and specifications of the product. But here, I have an admission from their general manager that he knew that it was being used for this purpose. So that's the first argument. The second argument they make is, well, you gotta prove that they relied on us. All right, I don't think I have to prove that, because both of those cases that I've cited in the reply say that if you know that a mass-produced product is being used by a subset of customers for a specific purpose, if you already know that, you don't have to prove individual reliance to. But let's assume I do have to prove that. Can I have the next one, Shane? This is an email that Mike Bush was the production manager of Real Water. So he sends this email directly to Milwaukee, okay? And he says, in the date of the email is February 22nd, 2019. This is about 2 years after they removed the oxidization kit because of the cancer problem. So he says, hello, please send us instructions on how to properly calibrate our older ore probes meters. Do the new meters need to be calibrated? And, you know, we find that the lay people use the term calibration, oxidization pretty much interchangeably. So anyway, he sends this email directly to Milwaukee. And what happens? What happens? Milwaukee sends an email back, and here it is. He sends, here's a link from our website. Here's how to do it. You see that link? It says conditioning negative ore probe. So what he sent him back is the instructions. He sent him back for the instructions for the conditioning solution. That says dip it in the conditioning solution for 5 minutes. This is what he sends him back, okay? And then we get to Mr. Brown's deposition where he testifies, I made a mistake. His term, twice. Can I have that, Jimmy? And what you should have done, if you knew he didn't have a cleaning kit, is tell him to put vinegar in it for 4 or 5 days, right? Yes. And that was your mistake. That was my mistake, yes, sir. So again, the person speaking here is the general manager of Milwaukee. He is admitting he made a mistake. Of course it's a mistake. You don't tell the guy to do it for 5 minutes with the conditioning kit when that's been off the market for 2 full years, okay? You don't tell him that, but he admits it's a mistake. So then I went back to Mr. Bush in the deposition to him, and I said, hey, you know, Mr. Brown said he made a mistake. Jason Brown, the general manager of Milwaukee, he said he made a mistake, and he should have put it in vinegar for 4 to 5 days. So this is what Mr. Bush says. If they had told us to put it in vinegar for 4 to 5 days, you would have done that, right? Right, yes, I would have. You didn't do that because your understanding was 4 to 5 minutes, right? Right, that's right. Okay. And again, if you recall, Lang Jones thought it was 5 minutes of vinegar. I showed you the thing from the instructional video. Twice, they said they gave him the wrong instructions. It was a mistake. And this guy says, oh, if they had told me the right thing, I would have done the right thing. I don't know how much you have to do to prove reliance, Your Honor. But let's get back to the subject of this motion, which is the specific purpose. Based on this evidence, I don't think there's any doubt that this entity, and again, 1/3 of the product was being sold to alkaline water makers. They knew the product was being made, used by alkaline water makers to take negative reading. I showed you the testimony of the general manager where we went through the request of admissions, and he said, well, whatever counsel put in there is wrong, we knew it. I showed you the reference to the email where he said we have tons, his word, tons of Kangen water customers, alkaline water customers. And against all this, they want to argue to the jury, oh, we didn't know what they were using the meter for, so we're not liable. We don't think that's right based upon this evidence, Your Honor, and for that reason, we would ask you to grant the motion for summary judgment. Again, just to this one part. We're not arguing that for determination that's not fit. Okay, we'll let the jury determine whether a probe that you got to stick in vinegar for 5 days before you use is fit or not. That's a jury issue. We're not asking for causation. we'll let the jury see the testimony about the inconsistent meter and what Mr. Akins did when he got the, you know. All we are asking for is that one of the particular purposes of this particular device is to take negative work readings when making alkaline water.